They were trained to face danger on the street. Some met it at home. In this video, we look at 4 relationships where an officer didn't make it back to roll call and the woman closest to him came under scrutiny. Jacqueline Villaseñor, Amanda Hovanek, Brianna Boileau, and girlfriend Karen Reed. We won't push you to a conclusion. We'll follow the record step by step. This episode involves domestic death and allegations of intimate partner violence. We'll avoid graphic detail, speak with care, and remember that people who loved these men may be watching. Where cases are unresolved, everyone is presumed innocent. Where facts are disputed, we'll say so. In this video, we're not chasing shock. We're building a clear timeline for each case, what's known, what's argued, and what remains uncertain. We won't reveal outcomes here. We'll focus on a few anchors that matter in every chapter. The last confirmed safe moment, the first sign something was wrong, and the choices investigators made in between. You'll hear what's in court records and credible reporting, labeled on screen, without speculation. We'll move deliberately, names and roles re-identified as needed, dates stamped clearly, and brief recaps so you never lose the thread. If you choose to watch, we ask for the same tone we're keeping, calm, respectful, and patient with the facts. Now, let's begin.
Case 1. Jacqueline Villaseñor and Officer German Villaseñor, Chicago, Illinois. There are addresses that look like every other address on the block. Same porch lights, same mailboxes, same late-night dog walkers. From the curb, nothing tells you that inside, 2 people are trying to hold a marriage and a life together, while the ground shifts under their feet. In Chicago, on a clear November night in 2021, that's the picture neighbors had. 2 off-duty officers, a husband and a wife, coming home to the same front door. Their names are important to say out loud. Officer German Villaseñor, a husband, a colleague, a familiar face at roll call. His wife, Jacqueline Villaseñor, also a Chicago police officer at the time. What happened in those few minutes between a private argument and a 911 response would ripple through a department, a family, and a city that knows too well what a folded flag looks like, but doesn't expect to see it carried out of a living room. According to court records, a personal crisis in the home escalated. Words that had been circling for days or months found their way to the surface. Infidelity was a fracture that had already cut into trust. Now it pushed past the point where talk could keep the peace. Jacqueline, off-duty and in distress, brandished a personal firearm. Her threat, according to those records, wasn't directed outward first. She threatened her own life. There's a truth about moments like this that anyone who's worked frontline jobs understands. When despair and weapons meet, everyone in the room is at risk, no matter who the weapon is pointed at. German did what many partners would do. He moved to intervene, to put his hands between a person he loved and the worst possible outcome. Training doesn't disappear in a home, neither does the instinct to save. What followed took seconds. During the struggle over the gun, a shot fired. We'll keep the details clinical out of respect. The round struck German in the chest. The house became a scene. The night became a timeline. From there, the process is as human as it is procedural. First responders arrive. They secure, they tend, they ask questions no one wants to answer. In the hours that follow, statements are given, often imperfect, often shaped by shock. Investigators begin the slow work of anchoring those statements to verifiable markers, dispatch logs, timestamps, location data, the physical realities of a room. 2 questions shaped what came next, and they're the questions that define many cases where a domestic crisis meets a firearm. First, was the discharge an accident amid a lawful attempt to disarm someone in immediate danger? Second, did the choices that led to that moment, introducing a firearm into a volatile argument, brandishing it, escalating the situation, rise to criminal conduct under the law? Intent matters in court, so does recklessness, so does the chain of decisions that put a loaded weapon in play. Forensic specialists examined the firearm. Was it functioning properly? Were there indicators of distance or trajectory consistent with a struggle? Those answers help draw the edges of a story, but they rarely finish the picture. In cases like this, the lead-up is often where the law does its hardest work. Prosecutors looked at the minutes before the shot, not just the mechanics of the shot itself.
According to filings later submitted, threats of self-harm and the display of a gun during a domestic dispute formed the core of the state's theory about criminal responsibility. The defense, in turn, emphasized the chaos of crisis, Germans' attempt to stop a tragedy, and the inherent risk of two trained people grappling with a weapon. Investigators also examined policy and training, the often invisible spine of law enforcement life. Off-duty weapon protocols, safe storage expectations, and the way agencies train their officers to navigate domestic conflict aren't bureaucratic trivia. In court, they can define what a reasonable person, especially a trained person, should do or not do when emotions are running hot. As the legal path took shape, Chicago's law enforcement community lived with a different kind of mourning. Losing an officer to street violence has its own awful script. Losing an officer in a domestic crisis challenges a department to look at the stressors that come home with the badge and at the gaps that training can't always fill. The criminal case reached resolution in 2025. In May of that year, Jacqueline Villaseñor pled guilty to involuntary manslaughter. The plea matters. It acknowledges criminal responsibility for a death without alleging an intent to kill. The sentence, more than 6 years in prison, answers in the language of the law, not the language of grief. For German's family and friends, the answer will always feel partial. A measure of accountability cannot restore a person's presence at the dinner table, in the locker room, or at a child's milestone. What should a viewer take from a case like this, beyond sorrow? 2 lessons worth carrying forward. First, crises involving threats of self-harm are dangerous for everyone nearby. That's not a moral judgment, it's a safety fact. Intervening is courageous, and it's unpredictable. Second, the line between tragedy and crime isn't always where the headlines place it. The law looks at a chain of choices. We can too. When weapons enter an argument, risk multiplies. When training enters a room, responsibility tightens. As you think about this case, hold both truths without letting either vanish the other. German tried to stop the worst outcome, and a sequence of escalating decisions led to the loss of his life. A courtroom can't fix grief. It can only measure conduct. Chicago measured. A family mourned. A department added another black mourning band to a badge and faced an uncomfortable mirror, the danger behind a familiar front door.
Case 2. Amanda Hovanek and Special Agent Timothy Hovanek, Wapakoneta, Ohio, April 24, 2022. In a small Midwestern town, the sound that starts rumors is often a siren, or silence. On a spring day in Wapakoneta, Ohio, federal agents would come to know the streets the way locals do. The long straightaways edged with fields, the neighborhoods where everybody knows who parks where. The case that took shape here wasn't the kind that begins with a shouting match overheard by neighbors. It was, according to federal filings, a crime of planning, precision, and concealment. Timothy Hovanek worked for the United States Department of State's Diplomatic Security Service. If you've never heard of the DSS, that's by design. Its agents protect people and information tied to American diplomacy. They chase fraud and threats most of us never see. It's a life that requires discipline. Then the workday ends, and home is home. Differences don't disappear because a job is complex. By April 2022, according to public records, Timothy and his wife, Amanda, were navigating a contentious personal conflict. You'll hear lawyers describe domestic matters with sanitized phrases. Don't mistake the clean language for calm. Family court schedules and custody disagreements can become their own kind of weather system, a pressure that weighs on every other part of a day. On April 24th, the driveway became the focal point. According to the plea agreement later entered in federal court, Amanda administered a dose of eutorphine, an extraordinarily potent synthetic opioid typically used in veterinary contexts. She did not, according to those records, act alone. Her mother and another participant assisted, including after the fact. The allegation was not just that a substance was used, but that a plan unfolded. Administration, death, and concealment by burial in a wooded area. We will not provide technical detail here. It's enough to know that eutorphine is powerful in micro amounts, strictly regulated, and dangerous to handle. Those very traits shaped the investigation. When the method of killing is a controlled substance, the inquiry expands beyond a scene. Investigators look for regulatory footprints. Who had access? Who searched for what? When did communication spike around a topic most households never mention?
According to federal filings, the case grew from multiple streams: phone records that mapped out communications before and after the afternoon in question, location data that drew lines on a map between home, supply, and concealment, and crucially, statements and corroboration that identified each person's role. When no neighbor hears a shot, the evidence of intent lives in a different thread. Messages typed quickly, purchases or movements that don't fit a routine, searches that point toward a plan. Federal prosecutors charged Amanda with distribution of a controlled substance resulting in death. That's not a state-level homicide statute. It's a federal law designed for situations in which a drug, legally obtained or not, becomes the instrument of killing. The legal questions shift subtly but significantly. Did the defendant knowingly distribute the substance? Did that act cause the death? What was the context and aftermath of that distribution? In plain terms, access, administration, and consequence. When a case like this unfolds in a federal courtroom, the public often hears less along the way. There are fewer cameras, fewer hallway interviews. Paper carries more of the story. In October 2024, the paper reached its conclusion: a guilty plea and a 40-year sentence. 40 years is a number that passes without a pause. It signals the gravity of using a controlled substance as a weapon and of orchestrating a plan that included concealment. For Timothy's family, the legal precision isn't the part that sticks. It's the absence. A person whose days were spent protecting others was not protected at home. In the face of a punishment that will reach across decades, grief remains immediate. Friends will still set an extra place at the table in their minds. Co-workers will glance at a chair in a briefing room and feel again the shape of a missing person. There are lessons here that don't depend on the specific names in the caption. One is about digital life. When crimes are planned, the planning often leaves a trace, if not in a text, then in timing, if not in a search, then in who called whom and when. The law has learned to read those trails. Another is about substances that most of us will never encounter. Their rarity is part of their appeal to people who mean harm. Their regulation is also their undoing. Strict control creates records. Records create paths back to the person who set the plan in motion. There's also a lesson about the institutions that pick up the pieces. In smaller communities, federal cases can feel remote, but they're often the right tool when the method is a drug that crosses state lines, international supply chains, or specialized use. A federal court has the jurisdiction and the penalties to meet that method with proportional accountability. You'll notice what we haven't done in this segment. We haven't turned a dangerous compound into a tutorial. We haven't diagrammed how to do harm. True crime done responsibly tells you what mattered to the case without teaching someone how to mimic it. What matters here is that access, planning, and digital evidence converged, and that the law treated a substance as seriously as a weapon. The gravity of a 40-year sentence answers a legal question. The human questions linger. How does a community understand that something like this unfolded, not in a spy thriller, but in a driveway on a quiet street? How do colleagues who've spent a career reading risk recalibrate their sense of what's possible at home? The only way forward is honesty in the telling, a complex method, a clear outcome, and a family left to carry more than the law can measure.
Some names carry significance beyond the person. In law enforcement circles, Hal was more than a first name. It was shorthand for a career, a reputation, and a lifetime of small interactions that make a community feel safer. When someone like that is killed, the grief is professional as well as personal. Former colleagues speak in present tense by accident. Old cases get pulled from memory. 1,000 "I should have called" thoughts surface and drift away. According to public reporting, on March 24, 2024, in Connecticut, Harold "Hal" Boileau was fatally shot during what authorities described as a domestic dispute. His spouse, Brianna Boileau, was arrested and charged with murder. This case has not gone to trial as of this recording, and that matters. In the United States system, a charge is not proof. The burden sits with the state on every element, beyond a reasonable doubt. That's not just a line from a civics class. It is the discipline that keeps storytelling from becoming a substitute for evidence. It's especially important here because people who knew and worked with Hal will naturally feel the pull of a narrative that makes sense of a senseless loss. The courtroom's job is not to satisfy that pull. It's to test what can be known against standards that protect all of us when we are accused. So what can be said responsibly in a pending case? We can acknowledge the anchor points, the date, the location, the charge. We can say the weapon, by public accounts, was a handgun and that the dispute was domestic in nature. We can repeat once more and again that the defendant is presumed innocent until the state proves otherwise. We can also lay out in general terms the categories of evidence that tend to matter in cases like this, without assigning them to this case unless and until they're presented in filings or in court. First, the first minutes, the 911 call, who made it, what they said, what the line captured naturally in the heat of a moment, the order in which responders arrived, whether the scene was secured quickly and cleanly. These practical details don't just protect evidence, they shape how jurors perceive urgency and state of mind. Second, the room itself. Scene processing is quiet work, measuring, photographing, collecting. Experts look for trajectory indicators, distance markers, and transfer patterns, but those indicators must be handled with humility. Gunshot residue can be transferred in many ways. Blood patterns that look telling in a TV show can be ambiguous in real life. Jurors who get clear explanations, what's objective, what's interpretation, are better equipped to weigh not just what is seen, but what can be reasonably concluded from what is seen. Third, the digital perimeter. Phones tell stories of ordinary life that become extraordinary in retrospect. Texts about dinner, bank alerts, a calendar block, a photo saved without a second thought. Location data can be precise in cities and slippery in the countryside. A lot of cases turn on whether a cluster of dots can be trusted to tell a story, and whether that story survives cross-examination. Fourth, the before. Prior incidents, if any, matter in specific ways under the rules of evidence. A judge can allow or exclude context depending on purpose and prejudice. The absence of prior reported incidents matters too, though in a different way. It can counter assumptions that a relationship was fragile, or it can remind jurors that not all strain is documented in paperwork. Either way, it should be handled with care. As pretrial hearings proceed, both sides will cast their cases in their strongest light. The state will argue that the material establishes intent, or at least the elements of the charged offense. The defense will challenge the collection, the chain of custody, the credibility of witnesses, and the inferences the state asks jurors to draw. That's the process working as designed, not as an obstacle, especially in a case with a victim who wore a badge in his own career. The system owes people like Hal not only remembrance, but rigor. The emotional terrain matters too. Communities sometimes rush to judgment when the accused is a spouse. It must have been X, people say, filling in gaps from television tropes. Real cases resist neatness. A domestic dispute can be ugly without being criminal. A shooting can be criminal without being planned. The task is not to find a story that feels satisfying. It's to find the truth the evidence supports. Where does that leave viewers who want to understand what's ahead? In a steady, disciplined posture. Watch the pretrial motions, what each side wants the jury to hear and why. Notice whether expert testimony will be contested and on what grounds. Pay attention to the judge's instructions. They are the map jurors must use to navigate the evidence. If and when the case goes to trial, listen for consistency. Do the core facts hold across multiple witnesses? Do technical explanations match physical realities? Do timelines align without forcing puzzle pieces into the wrong slots? And remember the human frame. Harold Hal Goyleau was known first to people, not to process. Friends will remember how he stood, how he laughed, the way he deferred credit or made space in a conversation. Those details don't belong in a verdict form, but they belong in the way a community carries a name forward. For Brianna Boileau, the presumption of innocence is not a courtesy, it is a right that prevents grief from dictating guilt. Holding both truths at once, mourning a loss and protecting a right, is the hard work of a mature public. We will update this case responsibly as the record develops. In the description, you'll find dates for upcoming hearings and, as they become available, links to formal filings you can read yourself. In the meantime, patience is not passivity, it is respect for a process that must do more than tell a story. It must prove one.
Case 4. Karen Reed and Officer John O'Keefe, Canton, Massachusetts, January 2022 to present. Disputed and ongoing. Some cases don't just enter the news cycle, they take it over. They become litmus tests for what people believe about institutions, fairness, and the possibility that alignments inside a community can pull an investigation off course or hold it steady against a storm. The death of Boston police officer John O'Keefe and the criminal case against his girlfriend, Karen Reed, is one of those cases. Here is what both sides agree on. In late January 2022, John O'Keefe spent the evening out with friends. In the early morning hours, he was found outside a home in Canton, Massachusetts, in winter conditions, and later pronounced dead. From that point forward, the narratives split. Prosecutors allege that Karen Reed struck O'Keefe with her SUV as she dropped him off, then left the scene. The theory is straightforward in its outline: vehicle, impact, departure. According to filings, the state points to physical observations on the vehicle, digital records of phones and movements, and statements from people at or near the home. Seen together, the state says, those elements form a chain that circles back to a single conclusion. The defense says the state is wrong, more than wrong. According to defense arguments in court, the harm to O'Keefe occurred after he went inside the home, not outside it. The defense alleges investigative bias, mishandled or overlooked evidence, and, at times, an active effort to force facts into a theory rather than the reverse. In their telling, the damage on a vehicle is misread. The timestamps that look definitive are less so under scrutiny, and witness accounts do not align with the physical and digital record. For viewers who haven't tracked the case, it's easy to get overwhelmed by dueling presentations. The antidote is method. Anchor yourself in what can be checked. There are 3 categories worth keeping separate in your mind. First, the fixed points. Who was where when, as verified by independent data, dispatch logs, cell site information, location services. Even those carry caveats. Technology has limits, but they set the frame. Make a list of the timestamps both sides agree on. You'll be surprised how much clarity that list offers. Second, the physical points. What was seen on a vehicle, at a curb, on clothing, what laboratory tests reported, what an expert says a pattern indicates. Physical evidence feels like bedrock. In reality, it comes with questions. How was it collected? How long after the event? Who handled it? And what records show that handling? What are the margins of error? An honest presentation embraces those questions. A selective one turns certainty where only likelihood exists. Third, the human points. Statements, memory, recollections given at 7 a.m. on a winter morning, then at 3 p.m., then in a formal setting days later. Inconsistencies happen for innocent reasons. They can also signal something else. The task is not to pounce on every difference, but to look for shifts around central facts and to see whether other evidence supports or undercuts those shifts. In this case, both sides have used all 3 categories to argue not just what happened, but how the public should feel about what happened. That's where the spotlight burns hottest. An officer is the victim. A girlfriend is the accused. A community knows the names of people who were in and around the home that night. Friendships, careers, and reputations sit inside the story like live wires. Any perceived misstep by investigators becomes an indictment of an institution. Any perceived bias by the defense becomes a rhetorical tactic to confuse. Then there's the reality of trial. Trials aren't Twitter threads. They require proof, foundation, and patience. The jury heard evidence. The jurors deliberated. They did not reach a unanimous verdict. In plain terms, the first trial ended without a definitive decision. A hung jury doesn't say who is right. It says that under the standards the law requires, 12 people could not agree. Where does that leave us? With a case still active, with lawyers preparing for what comes next, with filings and hearings that will continue to refine what evidence the jury will see and how they will be asked to evaluate it, with a family who mourns a man they loved, with a defendant who insists on her innocence, with a public that wants closure and must, instead, live with uncertainty a while longer. There is a discipline we can practice together as we follow the next steps. If you encounter a claim on social media, in a broadcast, in a casual conversation, ask the same 3 questions we posed earlier in the video. What do we know for sure, and how do we know it? What is being inferred, and by whom? What remains unclear, and is that uncertainty being honestly acknowledged? Apply that method evenly. If you favor one side, challenge your own assumptions. If you distrust one side, demand more than distrust. Ask for sources. There's also a lesson here that's bigger than a single case. The health of a justice system is measured not by how quickly it reaches a result, but by how reliably it does. Reliability can be messy. It can look like a halt in the middle of the road because the right answer isn't reachable yet. It can sound like a judge's instructions telling jurors to put aside emotion and to return another day to try again. Those instructions and the discipline behind them protect all of us, victims, defendants, and the people who are both loved and accused by their communities. For Officer John O'Keefe's family and friends, none of this provides comfort. A hung jury is not a tribute, it is a process note. The tribute is in the care with which we speak about him, in the refusal to reduce a life to the worst night, in the clarity with which we keep his humanity at the center of the conversation. For Karen Reed, the presumption of innocence is not a slogan, it is the system's way of balancing power until proof tips the scales. As future proceedings unfold, we'll update what we can verify, and we'll keep the tone you've heard today, calm, precise, and human. That doesn't mean cold, it means we let the record do the heavy lifting, and we resist the pull to dramatize what is already dramatic enough. A man died, a woman is accused, and a community's trust is on trial alongside the facts.